going to call the meeting to order, and Mr. Radikov.
Thanks. Just before we get going, just want to quickly talk about the minister visits. We have 3 on the books right now, and time is quickly running out. A lot of them are very time-specific. So just curious if we've been able to schedule a minister for 3 more times before the end of December.
I will ask the clerk to get hold of them and see when minister is available and when we can get him. Okay?
I just want to emphasize the importance of this because
I totally understand. That's why, I mean, I totally support on the other day. That's why I did not interrupt. In fact, I was the one who actively asked your motions to come forward and get it through, and that is the understanding. And you know that minister is very well accessible. He's been here already twice in a short period of time, and I'm certain that he and his staff will accommodate the times that work for him. Before I start the meeting, I would love to welcome some of the members new today that are with us. Madam Luce, welcome. Mr. Malilo, welcome to you as well. I know Mr. Albus is online, and Mr. Albus, welcome to this committee. Welcome to meeting number 83 of the House of Commons Standing Committee on Citizenship and Immigration. We are continuing our study of closed work permits and temporary foreign workers. For the first hour, I'm pleased to welcome the following witnesses. From the Canadian Labour Congress, we have Madam Kwan, Mr. Escobar, Mr. Anna Visca, and from the Canadian Bar Association, we have Madam Rameau. And welcome. My request to the honorable members, we will have a Spanish-speaking speaker today, Mr. Anna Visca, and you got to be a little bit patient because it's going to be, the work done by our interpreters is going to be great because we will be translating from, interpreting from Spanish to English, English to French, so as it can be accommodated simultaneously. So please be a bit patient, and I will make sure that if members' time, I will try to accommodate that time for sure. Okay, with that, I will directly go to the Canadian Labour Congress, and sorry. But okay, we'll get the screen on. Just give me a couple of seconds. Is online. Sorry, I don't know what's wrong. And we'll figure it out before we go. Pardon? This screen doesn't work because Mr. I'll call the meeting back to order. Now the technicality is fixed. I will give Canadian Labour Congress and Canadian Bar Association each for 5 minutes. Please go ahead with the opening statement.
Thank you, Chair. Good afternoon, Chair and committee members. Thank you for the opportunity to speak with you today. The Canadian Labour Congress advocates on national issues on behalf of 3 million working people. Today, I'm here with members of UFCW, an affiliate of the Canadian Labour Congress. For this study, the CLC recommends the following for the temporary foreign worker program, especially the low-wage streams. First, replace the employer-specific work permits with open work permits. Second, provide permanent residency streams for low-wage workers. Third, provide permanent residency streams for former low-wage workers who are undocumented. In the UN envoy's report, he stated that the agricultural and low-wage streams of the TFWP constitute a breeding ground for contemporary forms of slavery. We concur with this statement. The key reason lies with the impact of the employer-specific work permit that ties the migrant worker to one employer. The employer-specific work permit has a systemic impact of awarding all the power and control of the employment relationship to the employer, including the employment of the migrant worker, compensation, working conditions, and the immigration status. It simply renders migrant workers vulnerable and open to abuse and exploitation by employers, labor recruiters, and labor traffickers. The government says that TFWP workers have the same rights and protections as Canadians and permanent residents. However, the employer-specific work permit takes away the ability of migrant workers to exercise those rights. The fear of getting fired and deported traps migrant workers in involuntary servitude, generating a compliant labor force. Easy access to vulnerable migrant workers has resulted in TFWP employers using the program as an ongoing business model as opposed to a program of last resort to fill acute and temporary labor skill shortages. Thank you. I'm going to hand it over to Santiago now.
Good afternoon, Chair and committee members. UFCW Canada advocates for workers representing over 250,000 Canadians, including temporary foreign workers. For over 30 years, we have supported migrant workers in 80,000 cases, addressing open work permits for vulnerable workers, workers' compensations, Canadian pension plan, EA benefits, health and safety trainings, all in their languages at no cost. In 2010, the UN's International Labour Organization found Canada and Ontario violated the rights of over 100,000 agricultural workers by banning farm unions. Sadly, the response was no response. Canada has an obligation to protect human rights, which includes the labor rights of all workers. As it currently stands, the temporary foreign workers program, this system is a very poor reflection of Canada's stated commitment to human rights. The net effect in this creation of an environment where human trafficking is a shameful reality in our country. In June of this year, Jose and Karen Callejas were convicted of human trafficking in London, Ontario, with a survivor present here today. We aided these workers who sought our help back in 2018, fighting for justice for 5 years. Such suffering underscores the need for workers' representation and power balance mechanisms. Thank you for your work and this opportunity.
Thank you very much. 4 minutes. Mr. Anavisca, you want to say something?
Buenas tardes.
Good afternoon, Chair. Good afternoon, committee members. I am originally from Guatemala, and I'm a migrant worker. In 2016, I was recruited by an associate of Karen and Jose Callejas. I was promised a job in Canada. I was supposed to be packing turkeys with a salary of $16 an hour. And they also promised I could bring my family later. However, when I landed here, those promises were broken. I lived in precarious conditions, sharing a house with 8 other workers. There were no mattresses, and they once punished us by shutting the water off in the kitchen. Our freedom was limited, and a co-worker was physically abused by an associate of the Callejas family.
I will go to Madam Ramo for 5 minutes. Please go ahead.
Thank you. My name is Gabriela Ramo, and I'm the chair of the National Immigration Section of the Canadian Bar Association. The CBA is a national association of 37,000 members, including lawyers, judges, notaries, academics, and law students, with a 120-year-old mandate to seek improvements to the law and the administration of justice. Thank you for inviting the CBA to comment on the implication of closed work permits in the Temporary Foreign Worker Program. The observations we make today have been communicated to IRCC in written submissions, all of which are available in our website. The number of temporary foreign workers entering Canada on an annual basis continues to grow exponentially. The share of workers entering Canada through the agricultural and low-wage streams is quickly increasing. These workers are amongst the most vulnerable and at risk of abuse and often disproportionately racialized. We must ensure they're both protected from exploitation and abuse and also provided with opportunities for becoming permanent residents of Canada. The CBA agrees with the finding of the UN Special Rapporteur that the issuance of closed work permits to these workers, which prevents them from changing employers, increases their vulnerability for abuse. The issuance of open work permits, however, may also open workers to exploitation. While open work permits allow nationals to change employers, they provide no compliance mechanisms to ensure that employers provide foreign nationals with acceptable terms and conditions of employment. As they are also fully open as to the position in industry, they may also do little to address the labor shortages in particular industries that the Temporary Foreign Worker Program is intended to address. We make 6 recommendations today. Our first is the establishment of sector and occupation-specific work permits for low-wage and agricultural occupations. Sectoral work permits would allow individual foreign workers to work in a particular occupation in a particular sector, but for any employer in the sector who has registered with the program. Workers could move from employer to employer within the sector without having to obtain a new work permit by simply notifying the authorities of the change. The ability to change employers without having to wait for the issuance of a new work permit would prevent the creation of a dependency relationship between the foreign nationals, where the foreign national's immigration status is tied to remaining with the employer named on their closed work permit. A set number of LMIAs could be issued per occupation, allowing employers in the sector who've been pre-approved to hire workers in the specific occupation. To be approved, employers would need to undertake to provide workers with terms and conditions of employment set out in the LMIA. A website or portal would list employers participating in the program, as well as the terms and conditions of employment. Our second recommendation is that employers in the program should be subject to frequent and unannounced in-person inspections to review their compliance. Those found to be non-compliant and exploiting workers should face substantial penalties. To address the governance gap, the federal government should conduct inspections in coordination with provincial authorities responsible for enforcing employment standards and occupational health and safety. The current employer inspection regime follows a one-size-fits-all approach for high-wage and low-wage foreign workers. Given that high-wage skilled workers under the International Mobility Program are not vulnerable in the same way, we would recommend that inspection and compliance resources be shifted to the low-skill program to allow for increased and more thorough inspections. Our third recommendation is the establishment of specific PR programs for low-wage workers with substantial annual targets. The majority of low-wage and agricultural workers are generally unable to qualify for permanent residence because they cannot obtain the same level of points in areas such as education, language, arranged employment as high-wage workers. Allowing the annual admission of large numbers of low-wage temporary foreign workers who then have to compete with high-wage workers for a limited number of permanent resident spots available each year creates permanent guest workers who can never advance to permanent resident status. Our fourth recommendation is that the government implement tougher controls on recruiters and agents and work closely with local governments in source countries to enforce the prohibition of fees payable by foreign workers. This aims to address the serious issue of debt bondage. As the number of low-wage and agricultural temporary foreign workers in Canada continues to increase, so have the number of recruiters, consultants, and other agents who assist in recruiting foreign workers. Often, they charge the foreign workers large fees to assist them in obtaining work permits. Our fifth recommendation is that the foreign workers have access to clear and transparent information in their own language on how the program works, on the prohibition on the payment of fees to recruiters and agents, on their rights while in Canada, and on how they can report abuse. The government should also be transparent and ensure that vulnerable foreign nationals understand upfront that entering the program is not a guarantee path to permanent residence. Our final recommendation is that this committee expand its study to address the other substantial issues raised in the Special Rapporteur's report. Thank you for the opportunity to address the committee.
Thank you, Madam Rameau.
Sorry, point of order, Mr. Chair. I noticed one of the witnesses did take photos during the testimony, and I'd like you to speak to the witnesses about the impropriety of taking photos in this session.
I would request if someone has taken photographs, they should please delete because the photographs are not allowed. And we totally understand the witnesses might not know the process, but I want to thank Mr. McLean for bringing it forward. So my request will be if you could immediately delete those pictures, we would really appreciate that. And the proceedings are available online because this is in public meeting. So now, before I go to the honourable members, my request to the honourable members will be if they can point out their question, whether it's to the Canadian Labour Congress or Canadian Bar Association or particular person, that will accommodate the interpretation as well, help with the interpretation. So I will go with Mr. Radikoff for 6 minutes, and then I will go to Mr. Chang for 6 minutes. Mr. Radikoff, floor is yours.
Thank you, Mr. Chair. Is it Ms. Ramo or Ramos? Ramo, okay. Thank you for being here. Thank you to all of you for being here today. Ms. Ramo, in your legal opinion, is slavery against the law in Canada?
Leave the answer to yes.
Okay. Is slavery practiced in Canada? Have there been convictions, I guess, of slavery in Canada?
I'm afraid I do not know the answer to that question.
Okay, so it's probably safe to assume if it has been, it's a pretty rare occurrence.
Yes, it's a very rare occurrence. I am not aware of any.
Okay, thanks. So is a Canadian farmer paying wages to foreign workers who are here on closed work permits issued by the NDP Liberal government? Are they breaking the laws then?
If they are paying the wages that are set out in the LMIA that backs up their work permit and they're meeting their commitment to pay the wages and the hours and all the others terms and conditions of employment that are listed in that LMIA, they're not breaking the law.
Okay, thank you. And are closed work permits allowed under international law? For example, has the Canadian government been prosecuted by the International Criminal Court for Crimes Against Humanity or something like that for issuing such permits?
Not to my knowledge.
Okay. I want to ask you a little bit more. You had talked about the idea of a sectoral and a occupational work permit as maybe an alternative to what we have today. And maybe if you could explain why that is, why, in your opinion, you think that's better than having, say, an open work permit.
With the open work permits that we have today, and there's a variety of them, so you have open work permits, for instance, for the postgraduate work permit program, spouses of foreign workers, etc. With an open work permit, an individual can work for any occupation, for any employer in any location. There's no restrictions on them whatsoever. So if the purpose of bringing temporary foreign workers to Canada to work in specific occupations is to address labor shortages, an open work permit does not meet the goal. The issue with closed work permits is the inability of a foreign national to move from employer to employer, particularly in a circumstance when they're being abused. The sectoral work permits present a compromise, an ability to continue to have a program where individuals are working in a particular occupation, but by the same token, not leaving them in the position where their ability to remain in the country and their livelihood is completely tied to one employer. Under the open work permit scheme as well, there is nothing that gets tracked as to what the employer is being paid, et cetera. With closed work permits, either there's an LMIA backing them up, or there is something called the employer portal, where employers have to go in and put an offer of employment that sets out all the terms and conditions. From there comes the ability of the government to conduct inspections. If you have completely open work permits, there is no entry of that information anywhere, and those are not subject to the current inspection regime. So those workplaces, those employers would no longer be subject to any inspection in terms of how they are treating their foreign workers.
Thank you. So I guess just to make sure I understand, so if you're a farmer or an agriculture producer and you're expecting to have certain workers to take your crop off, for example, having an open work permit would put you at risk because those employees might go somewhere else. Is that?
Madam Ramo.
That is true, but more importantly, it also, what I'm saying is because there is no mechanism once you're on an open work permit, no one knows that foreign worker is working for that farmer. So there's no mechanisms to inspect what kind of conditions are being provided to the foreign workers. With a sectoral work permit, where the terms and conditions of employment would be listed and employers would have to sign on to agree to those terms and conditions, they could still be subject to inspections.
So one of the things you just mentioned was that the purpose of a closed work permit is to address labor shortages. I think that's what you said. Now, could you maybe just drill into that a little bit? So how does that work versus if it was, for example, an open work permit?
Madam Ramo.
The purpose of having the temporary foreign worker program in itself is to address labor shortages where Canadians aren't available for an occupation. An open work permit allows anyone to work in any occupation. So you might bring somebody in thinking they're going to come work in farms, but they could work in any other sector. Having a sectoral work permit would ensure that you have individuals working in the sector that has the shortages, but with the ability to move from employer to employer.
Thank you. I'm going to ask the Canadian Labour Congress, with respect to on-site inspections of workplaces, do you believe that ESDC should be out to bring employers into compliance with the rules, or should they be trying to punish them for infractions? What should be the priority there?
Madam Kwan.
The priority should be to put everything in place to protect the rights of the migrant worker in whatever the situation, whether it's farms or whether it's in your corner store or whether it's in a manufacturing facility. The point of the inspections is really, I think, if all the holes were plugged, so to speak, then the need for the inspections to be part of how shall I say, a stick rather than wouldn't be necessary. But it is necessary because of the way that the program is designed. So unfortunately, that is the case.
Thank you, Mr. Radikoff. We will go to Mr. Chang for 6 minutes. Please go ahead, and then Mr. Bruler-Decep.
Thank you, Mr. Chair. I'd like to thank the witnesses for being here today and giving your expert testimony today. My question is directed to Ms. Ramo. Thank you for your opening remarks and the points that you have raised. But as an expert in immigration law, do you believe recent reforms have effectively balanced the needs of employers with the protection of temporary foreign workers?
Madam Ramo.
I think that recent changes are a step in the right direction. For instance, the introduction of tighter rules around inspections and the expectations of employers that were introduced in September of last year, I think are a step in the right direction. I do think that there is still room for improvement, particularly on inspections. I think unannounced inspections would be an improvement to the current system.
Honorable Parliamentary Secretary.
Thank you. Thank you, Ms. Ramo. Then how can the Canadian government improve the integration of temporary foreign workers into society, considering the challenge they face, such as social exclusion?
Madam Ramo.
I think one of our messages and one of our key recommendations is having better pathways for permanent residency, particularly for the low-skilled and agricultural workers. We believe that permanent residence is the best form of integration possible, that where a foreign national doesn't become a permanent guest worker who is in Canada year after year without being able to enjoy the benefits of permanent residency.
Parliamentary Secretary.
Thank you, Mr. Chair. Then, in your experience, Ms. Ramo, what role does corporate responsibility play in ensuring fair treatment and protection of temporary foreign workers within multinational corporation?
Madam Ramo.
I think the role of the corporation is to ensure that the rights of workers are protected, to ensure that they work within all the parameters, not only of immigration law, but also employment standards, occupational health and safety rules. And I think the corporation also plays a role in ensuring that workers are aware of their rights and ensuring that they have mechanisms for bringing forth complaints, things like abuse tip hotlines, and also addressing complaints raised and ensuring that employees are protected.
Honorable Parliamentary Secretary.
And do you feel that, in your experience, do you feel that the temporary foreign workers should be granted automatic residency in Canada?
Madam Ramo.
I think there should be clear pathways, particularly for low-skilled workers and for agricultural workers to have access to permanent residency. So currently, the programs that we have in place, such as Express Entry and even the provincial nominee programs, workers in the low-wage screens find it very difficult to qualify for these programs. So I think that taking them out of that general pool and putting in place dedicated programs that, for instance, reduce things like language requirements and educational requirements so they have the ability to qualify for permanent residency without having to compete with more highly skilled workers.
Honorable Parliamentary Secretary.
Thank you, Ms. Ramo. Your nearly 30 years experience in the labor law, and do you feel the laws that we have in Canada is fair to the temporary foreign workers or close work permit people that are here?
Madam Ramo.
I think we need to differentiate between the different types of temporary foreign workers. So we'll have a variety of programs. For instance, there is the International Mobility Program, where the employers don't have to get a labor market impact assessment. Those are closed work permits, but the individuals coming into those programs, for instance, are intra-company transferees who have highly specialized knowledge or who are senior executives. I think the level of protections required by such workers is different than the level of protection required by the workers that the UN rapporteur was looking at, which is more the lower skilled and the agricultural sector, because those workers, by their very definition, are more subject to abuse.
Parliamentary Secretary.
Thank you. Have you had an opportunity to look at the UN Special Rapporteur's report, Ms. Ramo?
Madam Ramo.
Yes, I read the document that he provided in September of this year.
Parliamentary Secretary.
Would you say that's a fair assessment of what our temporary foreign worker rules are here for Canada?
Madam Ramo.
I think that the rapporteur brings up a number of issues which I think are very relevant in relation to closed work permits and also in relation to some of the activities of recruiters, particularly recruiters outside of Canada, and issues like debt bondage. I don't know that I would say I agree with everything in the report, but I think that there are many areas of the report that bear reviewing and addressing.
30 seconds, Mr. Parliamentary Secretary.
I will give up the remaining of time.
Thank you very much. And now
Thank you,
we
Mr.
will,
Ramo.
before I go to Mr. Bruno Duceppe, again, please speak when I recognize either the honorable member or the witness because of the translation into Spanish. Now, 6 minutes for Mr. Bruno Duceppe. Please go ahead.
Merci, Monsieur le Président.
Thank you, Mr. Chairperson. I can take my colleagues' remaining 30 seconds if you wish. Thank you very much, witnesses, for being here today.
Con nosotros para tener una conversación.
Thank you very much, Ms. Maresca, to participate in this very important conversation. I will thank.
This is a study that I wanted to see take place at this committee, and I'm delighted that my colleagues agreed to it in the first place. Now, obviously, one can't just set aside the UN Special Rapporteur's remarks. He has an important position on the world stage, and he made that statement and wrote that report. I'd like to know what you have to think. Perhaps my friends from the Canadian Labour Congress, what do you think of what the UN Special Rapporteur said? Is it true? And should it shake things up here in Canada and Quebec?
Thank you for the question. As I said in my statement, we actually concur with that statement from the UN Envoy's report. The reason why is because what he said was that the TFW, the agricultural and low-wage streams of the TFWP, constitute a breeding ground for contemporary forms of slavery, right? Which is, in my mind, a same way of saying that the program is structured to allow really, really nasty practices that harm workers. Now, it would be akin to us driving on the road with really strong, good laws about who can do what on the roads, but no one actually nabs the people who are very dangerous and cause accidents. So, you know, it really is, to me, that it is structured, it is systemic. I know that many people feel that it is about, you know, I'm a good employer or the other person is the bad employer. This is not about who's good and who's bad in employment. It's a structural issue that I'm speaking of.
Thank you. I'm a poor pupil. I didn't follow the chair's instructions, but I do agree with you. Now, the fact is that the vast majority of employers that take part in the Temporary Foreign Workers Program are good employers, and they want to access labour that just doesn't exist currently in Canada, and that's why they are turning to that program as a last resort. And perhaps folks will feel targeted by these remarks, and I think some of my Conservative colleagues took the UN Special Rapporteur's remarks a tad too personally. But is it possible to communicate to those people that they're not bad employers necessarily? We're just looking closely at certain employers that, and cases of abuse. Do you agree with the statement that the vast majority of employers are not abusing the labour force on a writ large?
I would say that if you were to invite ESDC to testify about the inspections they made and the numbers, right off the bat, the program in the last fiscal year, only 30% of the cases that they inspected that's based on high risk. So someone phoned the tip line, for instance, okay? Only 30% of those employers were compliant. The next section of employers, which is I don't know, I think it's 47%, had to be brought into compliance, and 10% were non-compliant. So, you're asking me yes or no. I would say that it's not so easy to say, right? I think that employers can do better, and I think that the program can motivate them and incentivize them to do better.
Thank you, Mr. Chair. So there are no good or bad answers, no right or wrong answers. I'm not trying to push any political agenda here. The status quo just clearly isn't working, and we need, evidently, to find other solutions in the place of this program. And I don't know what those solutions are, and that's why we've called you to appear before us to listen to your recommendations. So, Ms. Rameau, your recommendations. I'll turn to you now. The fact is that some employers invest heavily in order to bring foreigners to Canada to work on their farms, in their plants, in their small businesses. Now, if those people are told at the end of the day, well, the employee will have an open work permit, and if the business opposite offers them $1 more per hour, well, then they're just going to walk across the road and leave the initial employer, and the initial investment will be lost and wasted. What would you tell those employers who are...
Vous, Madame Kwan.
Ms. Kwan. Ms. Rameau.
Madame Kwan et ensuite Madame...
Well, in fact, both. Ms. Kwan and then Ms. Rameau on the same question, please.
Okay, go ahead.
Okay.
Madam Kwan.
First of all, I think for someone making so little money even if it's 10 cents an hour more, it makes a big difference to them. So that's the crossing the road, that situation that you described, right? In terms of the investment of the employers, the issue is that the program was designed for employees in the 1950s. I think attitudes have changed, and I think that the program must also change with it. I have to say, and please indulge me, because I also have trade files, and I look at the U.S. and I look at the EU, and I look at some of the rules that they have around migrant workers or around forced labor or around any of those human rights due diligence practices that they have. If Canada wants to compete, I would say this is a good place to start bringing the program up to speed and making sure that workers are protected under the temporary foreign worker program and paid and valued for the work that they do.
Very much, Mr. Bruno-Decep. It's 6:41, so I already accommodated the French-English translation. So we'll come back to Madam Rameau next round. Now I'll go to the Honourable Member of Parliament, Madam Kwan. Please go ahead.
Thank you very much, Mr. Chair, and thank you to all the witnesses for their presentations. I'm interested in understanding the recommendations for government. In this particular study, it is related to close work permits more specifically. But of course, as we know, temporary foreign workers come to Canada without full status, and as a result, many of them are subject to exploitation, abuse, and so on, too often and too familiar, really. Beyond the issue around closed work permits, I have a more overriding question, and that is, would you support for people to be able to come to Canada with landed status on arrival? So this first question to Ms. Kwan from the CLC, and then I would like to actually hear from Mr. Escobar on that question as well.
Thank you, Madam Kwan, and then Mr. Escobar.
I think that people should have rights and be able to practice those rights. So I would say that it is important to give them opportunities to immigrate permanently. I don't believe that there should be a two-step process. I don't know if that was part of what you were looking for in an answer, but I don't think that there should be a two-step process in terms of, kind of having a two sort of a differential system that, where a permanent immigrant from a high-skill stream can come in without having to work like 2 years, 3 years to prove themselves. I think that that's a differentiation that we have, and we need to get rid of that. We need to provide people with streams to get permanent residency, but quite frankly, the immediate step to actually deal with this in the immediate is to actually provide people with open work permits so they can come, then, have some of those streams open to the migrant workers so that they can exert their rights and have their rights.
Mr. Escobar.
I would like to share what we are doing right now as we speak. We support that migrants should have a better flexible path to PR. The Agri-Food pilot program was implemented by the federal government. Our members, temporary foreign workers, as we speak, are getting support. Our union is helping with ESL classes, with the process to file their applications to get PR. So these workers can qualify and get PR. So I think my answer would be that if workers are able to get PR, to become part of the community, is a win-win for all the parties involved, local communities, business owners, and of course, migrant workers and their families. And I think part of the solution is open work permits. As I can share myself, we have filed, because I'm part of the agricultural team in my union, so we have supported over 200 workers to obtain open work permits as vulnerable workers. We're talking about low-skilled workers that have experienced abuses. You cannot imagine all the abuses that we have been able to document it, starting from employees retaining their passports, living in inhuman and overcrowded conditions, threats. They have to achieve a set quota in order to be able to continue working. If they don't achieve the set quota every day, they are punished, and at the third time, they will be sent back home. So having said that, in order to make this society more inclusive to all workers, not just for high-skilled workers, low-skilled workers also should be included, and yeah, that's what I can share for now.
So on the question around open work permit, there's this belief that if migrant workers are given an open work permit, they will just disappear into the system. You can't track them, and they will actually not work in the sector that they were brought in for. But given that the vulnerable workers, open work permit, they're granted an open work permit. So, in particularly, I think with UFCW, you are working with those workers. Did they just disappear into the thin air, or were you able to identify these individuals and then actually line them up with employment, responsible employers, so that they can actually achieve what they hope to achieve, and that is to work here in Canada with a full respect and dignity and the laws on their side?
Mr. Escobar.
Unfortunately, what we have witnessed is that workers who have obtained open work permits have been blacklisted. So employers understand that if these workers obtain open work permit, it's because they came forward and they reported their former employers. So we are witnessing right now that hundreds of workers that have obtained open work permits as vulnerable workers ended up undocumented. And the solution for this is that if these workers had the opportunity to hold an open work permit, they would be able to leave an abusive employer. And I think abusive employers, I'm not telling all employers are abusive, but those who are problematic and abusive, they will think twice before they mistreat and abuse workers.
10 seconds, Honourable Member.
Okay. Any other recommendations that you would put forward to the government?
This is... Please, for your information, agricultural workers, local workers, and migrant workers in Ontario and Alberta are excluded from the Labour Relations Act. We claim as a union organization this is a labour issue, and if workers don't have the capacity to defend themselves by being part of a union, by being protected by a collective agreements, these workers are very vulnerable. So part of the solution is also include and give these workers the opportunity if they, to join a union. Thank you.
Thank you very much, Madam Honourable Member of Parliament Khan. We'll go to Mr. McLean for 5 minutes, and then we'll go to Madam Zahid for 5 minutes. Mr. McLean, floor is yours.
Well, thank you, Mr. Chair, and thank you, witnesses, for coming here today. I'm going to have to be quick because we have a few things we have to get through here. Mrs. Kwan, Ms. Kwan, you claim that ESDC is only 30% compliant on their inspections, and yet we heard previously in this committee when the department was here, ESDC, pardon me, that they were 99% compliant. How do you explain that quick differential? That's wide differential.
Madam Kwan.
There is no differential. They brought 47% of those employers into compliance. So that's how it added up to a big number. So like I said, there's a section that were compliant, and then there was a section that they brought into compliance, and then there was a section that wasn't compliant. The problem, my issue here is that, that 70% really, to start off with, is non-compliant. So why is it such a high degree of non-compliance?
Okay, thank you.
Mr. McLean.
And
you can raise the hand, then I'll stop the...
Ms. Ramo, you claimed about in the sectoral visa here. The issue about sectoral is usually the sponsor has to pay for the LMIA, the Labour Market Impact Assessment. Would you suggest that one party pay for it and then other people, other employers are able to take that employee after somebody has invested in that report? How do we get around that logistical challenge?
Madam Kwan.
No.
Madam Ramo, go ahead, please.
Thank you. Yes, you do have to pay for an LMIA. The proposal for the sectoral would be that employers would participate in that LMIA. So ESDC would set aside, and I'm picking numbers of 5,000 workers for this particular sector. Employers who want to be part of that program would pay for the LMAs in that program. If you have a worker that leaves an employer and moves to another employer, proposals for employers paying a proportional amount of the time on that LMIA. They're setting up mechanisms for ensuring that the employer who originally brought the individual doesn't pay the full brunt.
I will cede the rest of my time to my colleague, Ms. Lewis.
Madam Honorable Lewis, go ahead. You have 2.5 minutes.
Thank you. My question's for Ms. Ramo. I live in a community, Haldeman, Norfolk, that is highly dependent and reliant on foreign workers for agricultural processing. And I've spoken to many workers and also farmers. And one thing that they have in common is I met a worker that's been there for 8 years, and both the worker and the farmer have been trying to find a way for this person to get their permanent residency. Now, I know that there's programs, previous programs called the Living Caregiver Program, and they had, after 2 years, the ability to apply for permanent residency in a separate category. Is this something that you are contemplating in this program, and what is the compatibility between the two programs, or similarities?
Madam Ramo.
One of our recommendations is that there be a specific path to permanent residency for workers such as agricultural workers. My colleague referred earlier today to the agri-food program that has been allowing for permanent residency applications, but the allocation of spots for that program is very small. Setting up programs, and you referred to the Living Caregiver, yes, that was a specific program with specific criteria for those workers. That's the same idea. A similar program with specific criteria for agri-workers and for low-wage workers that doesn't pit them and have them compete head-on with high-skilled workers, with flexibility as to things like language and education.
40 seconds.
My next question pertains to the low-skilled sector. It was raised that they should have their permanent residency upon arrival. Can you name me one other NOC classification for a low-skilled worker that has that in place?
I'm not aware of any that have the ability to enter unless they qualify through what's called the skilled worker program, which is when you apply for permanent residency from outside of Canada based on your skills and your occupation and previous experience. But it would be very difficult for a low-skilled worker to achieve sufficient points to be able to access that program.
Exactly. So it doesn't apply there. Thank you.
Thank you.
And we will go to Madam Jahid for 5 minutes. Please go ahead.
Thank you, Chair. Thanks to all the witnesses for appearing before the committee. My first question is for Ms. Kwan. What do you think, what could the government do better to make sure that all the temporary and the migrant workers who come here are aware of their rights and, most importantly, that they are able to exercise those rights?
Madam Kwan.
Thank you for your question. I think that it's very important that all workers, but especially migrant workers, understand their rights when they're in Canada and how to exercise those rights. The problem is that when you have a closed work permit, it doesn't matter what shiny, strong rights you might have and award to them, which is what I said earlier in my statement, because if they don't have the ability to actually use that and fight for their rights, then it's very difficult. And so I believe the closed work permit under the Temporary Foreign Worker Program actually takes away, we give them the same rights as the Canadians and permanent residents, and then we give them also, this other thing called a closed work permit that takes away their ability to exercise their rights.
Honourable member.
Thank you, Ms. Kwan. So in regards to keeping a balance between the rights of the employers and the people who are here as temporary foreign workers, what do you think is the best way, or do you have any example of any other country, how they are doing these programs?
Madam Kwan.
I think that there are examples across different countries, but I also think that we have a system and that we're very invested in our system that we need to actually look at revamping the temporary foreign worker program so that, as I said before, it's up to date and that we are indeed being very competitive, with other countries.
Remember.
Thank you, Chair. How do we keep the balance so that the employee, because employers also spend a lot of money in getting the LMIAs and going through that process and making sure that the rights of the temporary foreign workers are also protected?
Madam Kwan.
I understand that, and first of all, I do think that there needs to be a big revamp of the program, but also the other thing that we have mentioned before is the IMP, the International Mobility Program. That program, has open work permits, and it has people picking apples, people providing childcare, people doing all sorts of, kind of so-called low-wage work, and yet we're not fussing and worrying about where those folks end. And so, I think that on one hand we have a similar kind of parallel system doing similar things on both sides, but we are basically having more judgment on one side, which is racialized low-wage workers under the TFWP.
Honorable Member.
Thank you. My next question is for Ms. Ramo. Ms. Ramo, if the government was to do away with the closed work permits and issue all the temporary foreign workers a completely open work permit, so what is your opinion? What do you think? What would happen in that scenario?
Madam Ramo.
There's a very broad stroke for a variety of different programs. I mean, going back to the issue of the International Mobility Program, yes, there are open permits under the International Mobility Program, such as the postgraduate work permit holders that are given to work permits that are given to individuals who've completed education in Canada. We have spouses of foreign workers are given an open work permit, but we also have a broad variety of closed work permits under the International Mobility Program. Intracompany transferees, individuals who bring significant benefit to Canada. The reciprocity, there's professors. I think the list is over somewhere between 100 and 200 different programs, and all those are closed. I think if you opened all of these work permits became open, I think that would be detrimental to Canada. I think
50 seconds, Honorable Member, for you.
Just quickly, if you can indicate when many temporary foreign workers come, their spouses are getting the open work permits. How do you think is that working?
Madam Ramo.
Sorry?
How do you think is that working?
That's working. It's a substantially smaller number of people. They're the spouses of high school workers who are going to be in Canada for more than 6 months, and it is a tool to allow for those types of transfers because in today's society where most people are in dual income households, it becomes very difficult to attract foreign nationals to work in Canada if the spouse is not able to work.
Thank you, Madam Jahed. Right on 5 minutes. Now we will go to Mr. Bruno Decep, 2.5 minutes plus the accommodation, French to English to Spanish. Thank you.
Merci, Monsieur le Président.
Thank you, Mr. Chairperson. Mr. Escobar, you said that you support vulnerable workers to help them get open work permits on the basis of vulnerability or abuse. There's an organization called the RATMAC, which is based in Quebec. It's the Quebec Farm Workers Advocacy Network, so you're aware of it. Now, they spoke to me late last year to tell me that all of a sudden the advocacy work that they were doing and the applications that they were filing for an open work permit on the basis of vulnerability, that they were being denied almost systematically. Have you experienced the same problem?
Escobar.
Yes, we share the same findings as RACMAC. We collaborate with many agencies, community agencies like this across Canada, and we have identified that for some reasons, unknown reasons, the claims, the open work permits as vulnerable workers are denied. So, for instance, the first 2 years of the program, we had a very high scores of approvals, and now it's very little. So, even though we are providing very strong documentation to show that workers have experienced abuse, news, we have witnessed that is, for some reason, unknown reasons, their claims are denied.
Honourable member.
Donc vous avez jamais.
So you've never gotten to know why this is happening?
Ok, merci.
No.
Thank you. Mr. Chairperson, Mr. Anaviska hasn't had an opportunity to speak up yet. If you have something to say, sir, to the committee, given that this is your final opportunity to do so, I'll give you that speaking time.
Thank you, Mr. Anaviska. You have about 35 to 40 seconds.
Claro.
Yes, thank you, Chair. If we were given an opportunity to get these open work permits, we wouldn't be subjected to a specific employer and we wouldn't be put at risk of being abused because we are given extra work all the time and they are not very well paid. We've been mistreated and abused. If we had an open work permit, we would have an opportunity, as the colleague here said, we'd have an opportunity to find a better job, to be able to work better, better living conditions. Muchas gracias.
And now we will go to Honourable Member of Parliament, Madam Kwan, for 2.5 minutes. Please go ahead.
Thank you very much. I was actually also going to ask Mr. Anaveska to see if there is anything specific that he would like to ask of the government to take action on. So beyond the open work permit piece, is there anything else that you would like to ask the government to take action on?
Mr. Anaviska.
Claro.
Yes, thank you. Well, in addition to the open work permit, we would like to have an opportunity to get the PR, the permanent residency. That would be a great addition. Of course, through the unions, for example, I was held by UFCW. They'd helped me throughout this process to be able to get a PR. I was given that permit, but then it was denied. And for 5 years, I've been struggling and striving to find a permanent residency. I haven't gotten any specific support, and I'm still fighting to get it.
Have a immigration stream that brought in the full range of workers. I don't like the term low skill or high skill particularly. They're all actually important workers, and as we learned through the COVID period, those so-called low skill workers were essential workers. Should Canada be bringing back a immigration stream that brings landed status, gives landed status for the full range of workers? If they did that, would that not address some of the situations to which the rapporteur calls contemporary slavery here in Canada for migrant workers? So I think very quickly for Ms. Kwan and then Mr. Escobar.
Madam Kwan and Mr. Escobar, you have about 35 seconds.
Okay, I would say yes to that question. And in fact, we have been saying to the government that, they should create those streams because there is currently an exclusion of so-called low-wage people who are interested in immigrating to Canada. They still have to come up with that.
Mr. Escobar.
Yes, as you said, Honorable Juan, during the COVID pandemic, we were able to acknowledge, finally, the hard work of these men and women that have been coming to Canada under the temporary, that is not temporary anymore because it's already been going for over 60 years. So I think it's time to give to these workers what they deserve. I met some of these workers that have come here to Canada for the last 4 decades, and they don't qualify to obtain PR. So I think it's time to give justice to these workers and, provide a flexible path to PR. And like I said before, it's a win-win for all the parties involved.
Thank you. I want to thank the witnesses for their appearance and your contributions on behalf of all the members and myself as a chair. Thank you, and meeting is suspended for the next round. meeting to order, and I would love to welcome Mr. Perron and Mr. Leslie to the meeting as well. And now, before we go to the witnesses, I want to thank the honorable member. The way we handled last panel, it was perfect because it helps the interpreters the way we did it. And if we continue to point our questions to a particular person, that would really help. And I would now welcome the honorable members I already welcomed. So I'm pleased to welcome the following witnesses from Canadian Agriculture Human Resource Council. We have Peggy Breckbelt. And from the UPA, we have Paul Doan and Dennis Roy. Please go ahead, 5 minutes each. If you can go ahead, and I'll start with the Canadian Agriculture Human Resources Council. You have 5 minutes from now for the opening statement.
Thank you. Mr. Chair and members of the committee, thank you for the invitation to participate in this study. My name is Peggy Breckfeld. I'm the chair of the board of the Canadian Agricultural Human Resource Council. My comments today will focus on the value of temporary foreign workers to the Canadian agriculture industry. The
interpretation is, sorry to interrupt you, Madam Breckfield. I have to fix interpretation here somehow. Meeting is suspended. To order, and we will go to the witnesses from UPA. Between two of you, Mr. Doan and Mr. Roy, you have 5 minutes from now. Please go ahead for your opening statement.
Merci. Thank you, Mr. Chairperson. My name is Paul Doyen, Deputy Vice President of the Union des Producteurs Agricoles, UPA, and I'm also a dairy and maple syrup farmer. I'm accompanied by Denis Roy, our immigration consultant at the UPA. The recent report by the United Nations Special Rapporteur, Mr. Obokata, was the catalyst for this study. Since the UPA is directly involved in temporary foreign agricultural worker programs in Quebec, we would have liked to have been invited to speak with the rapporteur. 5 years ago, the UPA set up a roundtable for temporary foreign farm workers in Quebec. A roundtable that brings together representatives of employers, workers, and all relevant departments, ministries, and agencies, both federally and provincially. Its mission is straightforward: to ensure the success of programs for employers, workers, and their families. These individuals are essential to the food security of Canadians. The stability and protection of the workforce on our farms is therefore paramount. In Quebec, employers' advocates, community groups, government agencies and consulates in workers' countries of origin ensure that they have all the information they need to be able to work with dignity whilst upholding the laws and their rights. In the event of problems, the UPA has agreed to a collaborative agreement with a workers' advocacy group to be able to intervene quickly. The UN rapporteur does not appear to be familiar with the type of work permits under the Seasonal Agricultural Worker Program. It's a type of open work permit unique to Canada, through which the worker can be hired by another employer authorised by a specific labour market impact assessment, an LMIA. This change of employer can be done very quickly, in less than a week, in the event of an emergency. The UPA has long advocated for this type of open permit to be applied to temporary foreign workers in the agricultural stream. As the UN press release mentions, government processing times are too long. Today, for a worker who is in Canada and applies for a new permit, Immigration, Refugees and Citizenship Canada takes 27 weeks to process that application. Government services need to be improved, streamlined, and they need to be faster. For this reason, we recommend that Service Canada process LMIA applications in fewer than 5 days. Immigration Canada should automate the issuance of in-Canada work permits similar to those held by other work permit holders and issue them in fewer than 5 days. So in a 2-week time frame, a person could change jobs. If these time frames were in place, Canada would have avoided many of the grievances raised by the United Nations. Section 207.1 of the Immigration Regulations provides for an open work permits for vulnerable workers, but many people aren't aware of the existence of this provision. To facilitate access to the permit, Immigration Canada should come to an agreement with Service Canada so that workers can also submit their applications at its offices, given that Services Canada has 591 points of service across the country, whilst Immigration Canada has only 22. In addition, every single application for a work permit for a vulnerable worker should trigger a serious investigation into the allegations so that the culprit can face the consequences. We also want to share some concerns and misgivings about the open work permits other than those under the Seasonal Agricultural Worker Program. The most important is that an open work permit does not identify an employer. Consequently, it becomes impossible to carry out inspections to ensure that workers are not being exploited unscrupulously. In addition, it is inappropriate for a person to enter the country for a farming job when their true intention is to work in another field. The work permit must demonstrate that the job matches the temporary foreign worker's skill set. We are in favour of labour mobility as long as it is not improvised and it is well managed. Bringing in a foreign worker is a lengthy process for which the employer has to pay significant sums of money. Employment contracts signed by an employer and the employee are always for a fixed term. However, in the event that a worker leaves their job without cause before the end of their contract, the employer must at least be able to obtain compensation from the new employer or the worker themselves. Also, there should be a mechanism to fast-track the replacement of a worker who has left their job. We are calling on the federal government to expedite the processing of LMIAs and work permit applications in Canada, to raise awareness about the existence of emergency work permits for vulnerable workers, to work with the provinces to inspect employers.
Pardon?
Sorry, I didn't hear you.
You already have your 5 minutes.
Okay.
Thank you.
Merci.
We'll go to Madam Breckwell and see if it works now. Madam Breckwell, you have 5 minutes from now. Go ahead, please.
Thank you. Mr. Chair and members of the committee, thank you for the invitation to participate in this study. My name is Peggy Breckfeld, and I am the chair of the board of the Canadian Agricultural Human Resource Council. My comments today will focus on the value of temporary foreign workers to the Canadian agriculture industry. The Canadian Agricultural Human Resource Council, or CARC, has been examining the workforce needs of the Canadian agriculture system for more than 15 years.
Hold on, Madam Breckfield. I will see
Juste que vous sachiez que les interprètes.
If you could just be aware, Mr. Chairperson, the interpreters have just pointed out that the quality of the sound is inadequate, but they do have the written text. They'll be able to read out loud the interpretation of the brief, but it'll be a bit more difficult for the question and answer period because of the poor sound quality.
C'est bon?
Thank you. Should we carry on? Yeah, we carry on with the statement. So we'll carry on with the statement, and then we will figure it out when we get to the questions and answers. And she might be able to submit those questions in writing, answer to those questions in writing if we need to. Okay, so we will continue now. Sorry, Madam Blackwell, back to you, and you still have 4 minutes.
Sorry, Mr. Chair, before you go back to the witness, could we just get clarity with respect to the problem on the sound? Is it because we don't, the witness does not have the right headset, or what seems to be the source of the problem? I'm just wondering.
Let me pass it on to Mr. Clerk. Mr. Clerk, you want to respond?
The headset is approved. Those tests have to happen. The appearance wouldn't take place if the headset weren't approved. It's unfortunately, it could be a connection issue. That's all we know at this point. So.
Okay, if members are okay, should I continue? Okay, sorry, Madam Blackwell. Now you continue. You have still 4 minutes and 23 seconds.
Merci. Thank you. CARC, along with the Canadian Federation of Agriculture and Food and Beverage Canada, is also leading the National Workforce Strategic Plan for Agriculture and Food and Beverage Manufacturing. Together, we have engaged industry stakeholders on ways to address work shortages. CARC's most recent labor market research, which was released only a few days ago, November 1st, 2023, illustrates the critical role the agriculture sector plays in the Canadian economy, both fulfilling domestic and global food, fuel, and fiber demands. In 2022, the Canadian agriculture sector generated $38.8 billion in GDP, or 1.9% of the national total. Canada has established itself as a major producer of diverse and high-quality agricultural products. It ranks among the world's largest exporters with $92.8 billion in agricultural and processed food exports in 2022. Secure access to an affordable, safe, and reliable food supply for both Canadians and the world relies on a skilled and motivated workforce. The success of agriculture and its sector does as well. The data is impressive. Agricultural sector, including crop and animal production, support services, and agricultural wholesale, employ over 351,000 Canadian workers and 71,000 temporary foreign workers, including seasonal ag worker program workers in 2022. Even with these additional workers from other parts of the world, the industry is still experiencing 28,200 job vacancies the same year. Over the next decade, expanding global markets for Canadian food products are expected to drive substantial growth in this sector. The challenge is to meet this growth will need strategic responses. There are several ways the industry is planning to address this. Part of that response will need to address a labor shortage that is already present and likely to grow. The National Workforce Strategic Plan is examining this issue. The care and well-being of agriculture workers, both domestic and foreign, is the top priority of agriculture employers. Agriculture employers work very closely with Immigration, Refugees, and Citizenship Canada, Employment and Social Development Canada, and Services Canada to ensure the oversights and regulations are in place to protect workers and employers, and that the processes continue to improve and that bad actors are rooted out. The industry's goal is for workers, both domestic and foreign, to choose agriculture as a place to work. Having a stable, predictable, fully functioning workforce will benefit employees, employers, and our food system. We know that Canadians deserve a stable food system, and so do the countries that depend on us for food worldwide. I look forward to questions from the committee, and thank you.
Thank you, Madam Brackwell, and we will go to questions and answers. We have only time for one round. So we will go 5.5 minutes each, just so that we have a couple of minutes for our committee to do something. So the first round, or there are only one round, and we will do 5.5 minutes. And we will start with Mr. Leslie for 5.5 minutes. Please go ahead.
Thank you, Mr. Chair. Pleasure to join this committee. I'll start with my questions for Peggy. Understanding your background working with the agricultural sector, both Carc and as a farmer yourself, obviously.
Hold on, Mr. Leslie and Mr. Perrin.
Ouais, je suis désolé, j'arrive dans votre comité.
I'm sorry, I've just kind of been parachuted into your committee and there seems to be a lot of issues, but the interpreter has just indicated now that the quality of sound from the witness isn't good and that it'll be difficult to do the questions and answers. But right now, her microphone must be turned off in the meantime because her mic was left on.
Okay, so Madam Brackfield, if you can turn your camera off and see if the quality improves. And also turn your microphone off as well.
Turned it on now, but I will turn it off.
Sure, please. And when you speak, and try to turn your camera off and see if it improves.
I'm speaking now, if that is improved.
No, we got to see your picture.
She has to turn her microphone off while he's talking.
Oh yeah, that's right.
That's what he's saying.
Okay.
Right?
Okay, I'm going to reset the clock.
C'est ça.
Non, pour les questions aussi.
Now let me see how many minutes. We have 4, 5 minutes each. That's good. Still 5 minutes each. Okay? Makes sense? Because we are bringing her later, we still have 5 minutes each, right? Okay, let's go. We will start with Mr. Leslie. Go ahead, please.
Thank you, Mr. Chair. I will go to our other witness, UPA, to answer a couple of questions. I'm from a farming background, so I have an understanding. In my area of South Central Manitoba, we have a lot of vegetable production. We have slaughterhouses. We have some wood manufacturing. So we have TFWs being a very important part, as well as the agricultural program, bringing folks in. And in my experience of the many individuals that farm fields next to my family's farm, and speaking with many of these individuals, they are generally happy. They return year over year, and they are well cared for by their employers. And I think our fellow panelist that's no longer with us mentioned about rooting out some of the bad actors, and I think that that's an important part of this. But I'm wondering, perhaps Mr. Doyon or Mr. Roy, if you could explain what your experience in the Quebec system is in terms of the way that farmers engage with and care for TFW employees on farm.
UPA witnesses, go ahead, please.
Well, I'll defer to Denis. Thank you very much. So we represent all the farming employers across Quebec. The UPA has 12 regional offices, and in each and every one of those offices, we have what we call an agricultural employment centre. Now, that centre is funded to a large extent by the Quebec government under Canada-Quebec Labour Development Agreement. And the priority in our regional offices is first and foremost Canadian and Quebec and local workers. But as everyone's fully aware, there's a dearth of local workers to fill all the positions on farms. So therefore, we support employers in their quest to fill out applications to bring in temporary foreign workers. Now, as Mr. Doyon mentioned, 5 years ago, we put in place a roundtable. Departments, ministries, stakeholders, and employers' advocates, including those from the RATMAC and TUAC, the Commission for Equity, Occupational Health and Safety Standards in Quebec, the Human Rights Commission, as well as federal departments such as Services Canada, Immigration Canada. They are members on that roundtable.
Just to kind of expand a little bit further, the conversation surrounding the UN Special Rapporteur on contemporary forms of slavery has indicated that folks working in our agricultural sector here in Canada are under some sort of contemporary form of slavery. In your experience, beyond the roundtable, and I understand the work that you've done within your departments, within the organization to try to fill local employees first, which is what I think every business is obviously always aiming for. In your experience, is that an accurate assessment of farms in Quebec?
Mr. Roy.
No.
No. It's not an accurate assessment, nor a complete assessment of this state of affairs. In the case of each and every case of abuse, well, that's one case too many, and the UPA has a 1-800 tip line with a regional office, and it's supported by a federal program, and we take calls from workers. We also have direct contact. In Saint-Rémy, we look at the tax returns of over 22,000 temporary foreign workers. That provides for a direct link with workers, and there's a lot of dialogue to hear about their concerns, and we help them so to have their rights upheld. There is also an agreement.
Thank you, Mr. Chair. Just to summarize that question, because it was a lengthy answer to a lengthy question. In your view, do Quebec farmers care about their employees, whether they be local or TFW or agricultural seasonal workers?
Mr. Roy. Quick question, quick answer, please.
Yes, absolutely they do.
Thank you very much, Mr. Leslie. Right on time. So we'll go to Mr. Alcoy for 4.5 minutes. Please go ahead.
Merci, Monsieur le Président.
Thank you, Mr. Chairperson, and welcome to our witnesses. Mr. Doyon, you referred to a roundtable in Quebec, and you hold quite a few meetings in order to advocate for the interests of foreign workers. Here's what I'd like to know from you. What has that roundtable done to ensure that vulnerable workers are aware of their rights as workers in Canada. Go ahead, Denis. Under Agri-Carrière, we have organised initiatives as of the first year of COVID to meet workers in their workplace to broaden awareness about their rights, how they can advocate for their rights and have them upheld. We also have dealings with the CNST in order to identify employers and encourage them to welcome government representatives and explain workers' rights to them. So there's a lot of concrete action. This past summer, we organised a fiesta in the Laurentians so that foreign workers and employers, well, the employers, in fact, brought them to the fiesta, helped them with transport to get there. There were kiosks with employers' advocates to inform workers about their rights. So there's a whole host of methods of communication that we take advantage of and tell workers that they must be respected by their employers. There's a lot of training that targets employers as well to ensure that they uphold workers' rights. Mr. Roy, foreign workers are always concerned about being deported, always concerned that they're going to lose their jobs. They're always concerned that they're not going to have enough money to send remittances to their families. Now, what steps have you taken to ensure that those people feel safe, that they don't have to be afraid when they feel that their rights are in jeopardy so that they can speak out and blow the whistle? Well, sir, you've asked an excellent question. I think that all Canadians have a joint responsibility in that realm. Now, there are often cultural exchanges that are organised in the countries of origin. And in fact, when these workers come to Canada, we want them to know that they enjoy the same rights as Canadian workers, and if something's wrong, all they have to do is raise their hand, speak to the boss and say, listen, this isn't working for me, there's a problem in terms of my housing, there's a problem here in the workplace. We encourage foreign workers to consider themselves just like any local worker, and this is a responsibility that lies on all of our shoulders. We need to encourage workers to speak their minds, to share their fears, and to help them to meet their financial objectives and allay any fears of deportation. As soon as those kinds of things are brought to our attention, we provide the workers with the proper information. If things aren't working in their workplace, UPA and our collaborators across Quebec go to great lengths to find a new employer so that that employee can be transferred legally. It's a little bit too long to get, it takes too long to get a second work permit. That's why we advocate for an open sector-based work permit for farm workers, most of whom come from Guatemala, and they come in under the agricultural stream, temporary foreign workers. There's also training in Spanish to help those foreign workers who are Spanophones. I've run out of time? Okay.
Merci à vous deux.
Thanks to the both of you.
And we will go to Honourable Perron for 4.5 minutes. Please go ahead.
OK. Merci beaucoup, Monsieur le Président.
Thank you, Mr. Chairperson. Thanks to the witnesses for being here. So I have 4.5 minutes. We've understood we don't have much time together. You've made a number of recommendations in your opening brief. Now, if you'd like to provide further detail, please feel free to submit it to the committee clerk so that we get a full sense of what your recommendations are. Now, when it comes to the Foreign Workers Roundtable, it seems to be something that's happening in Quebec and not elsewhere in Canada. Could that be a recommendation that that kind of structure be set up in other provinces? Response: yes, perhaps. In Quebec, we have a lot of fora, like the Commission for Work Partnerships. So there are many fora for a dialogue. I'm sorry to cut you off, sir. you did explain that earlier. I don't want to be impolite, but we're short on time. Now, you made another proposal for sectoral-based open work permits. Everyone is aware that we need to overhaul the closed work permit system, but the danger that I see here, and I'd like to hear your thoughts, is the risk of a breach of contract. It's an agreement you enter into with a foreign worker. You bring that worker to Canada, and it's an expensive process. And I'd like you to tell me, on average, how much it costs to bring in a temporary foreign worker to Canada or Quebec. And if that employee changes jobs a couple of weeks later just because another employer is going to pay them $1 more an hour, what kind of losses does that amount to for the initial employer? And so I'd like to hear your thoughts on those matters, please. Well, the work contract is signed both by the employer and the employee for a set period, and that contract has to be upheld by all parties concerned. It's very clear. Now, in the case of farm workers from Guatemala, they arrive, they start the strawberry season, then they change employers to the apple orchard, and they require a second work permit. So in those particular cases, we would like a sector-based work permit so that they, just like the Mexican temporary foreign workers can avail themselves of in Canada. What about the cost? About $1,000 to $10,000 per worker, depending on how skilled they are, what their competencies are. That's how much it costs. Now, when it comes, of course, when you say that the contract has to be respected, as long as they're not mistreated, that's right, in which case they'd be transferred very quickly. Now, you've said that Services Canada should be the ones processing these applications when there's a change of employer. Response: yes, Services Canada produces the LMIAs, and it takes 3 or 4 weeks. We're calling for a labour market impact assessment that would take 1 week, and then for the second work permit, it's currently taking 27 weeks processing time. And we want CIC to automate the second work permit, given that it's in farming, after all, and it shouldn't take a fully fledged analysis over a period of 6 months. It should be done automatically in a 1-week time frame. That's our proposal. This can be done legally. Even with a closed work permit, employees should be able to change employers in a 2-week time frame. Well, there are stakeholders earlier that said that perhaps there should be a pathway for permanent residency for those who would like that. Now, I'm sure that there are a lot of farmers who would like to assist their employees to come and get permanent residence. What would be your proposal to facilitate that kind of thing? Well, for quite some time, we've been advocating for permanent residency for those foreign temporary workers that wish to become permanent residents. We're discussing it with Minister Fréchette. That is within the purview of Quebec's immigration ministry. Thank you for saying that, but we're here to talk about all the provinces at this committee. Do you have anything to add in the 10 seconds remaining? Please go ahead, Denis. Well, when it comes to the emergency work permit for vulnerable workers, we believe that there needs to be a broadening of awareness about the existence of that work permit. It's been in place since 2019, and yet it's not understood, and the information hasn't been widely disseminated. RATMAC has told us how important this is, and there have been a number of irregularities that they have sought to address. Services Canada should welcome those kinds of applications from workers who are vulnerable or exploited.
Thank you very much, Mr. Roy, and thank you, Mr. Perron, and appreciate that. Now we will go to Madam Kwan for 4.5 minutes. Please go ahead.
Thank you very much, Mr. Chair, and I really appreciated the last comment related to ensuring that temporary foreign workers actually can get permanent status. We heard from the previous delegation from the UFCW, Mr. Santiago. He's been working in this sector for some time now, and in fact, he's met people who's been who are temporary foreign workers for decades, 40 years, and still they only have temporary status. Now, it was reported in the media, and one of the witnesses was one of the farm workers who were subject to exploitation in our previous panel. In that situation, as we learned, the operators of an agriculture business in London, Ontario were recently convicted by a jury of 7 counts of human trafficking. A group of Guatemalan agriculture workers who had valid close work permits issued by IRCC under the Temporary Foreign Workers Program left the employers that their permits were tied to due to abuse and were recruited by another farm in Southern Ontario under false pretenses. And they testified that their passports and identification were withheld and that they were subject to poor living conditions and that they were forced to work. The RCMP said that the housing they were provided were borderline on inhumane. And that is the reality to which some of the temporary foreign workers are faced with. And so to that end, we're not, I guess my concern is not for the employers who are not the bad actors. My concern, of course, are the employers who are the bad actors, where people are subject to exploitation. In the process, and I have met with some of these workers who's faced that kind of exploitation, the process is not as easy as to say, just go talk to your employer and they will fix it. Nor is it just as easy as for them to make a complaint and then everything would be okay. Some of them actually do get fired. Some of them lose their employment. And because they are tied to their specific employer, they will then be deported. And then that leaves them into all kinds of faced with challenges because they're here to make some money to send back home, not only to support themselves, but that of their family as well. So in the face of that kind of scenario, I guess my question is this. When it isn't actually that easy for a employer who don't have the power or the control over the situation, how can they ensure that their rights are actually protected? What action should the government take to ensure that their rights are protected?
Mr. Roy. Mr. Roy, go ahead.
Merci. Thank you. Well, in Quebec, there's an employer that's in the headlines by he's abusing workers, and he's been reported for doing so for a number of years. So we are fully aware of this deplorable situation going on. We're working very closely with RATNAC, which is the Quebec Farm Workers Advocacy Work. They have collaborators out in the field with a view to finding quick solutions for those workers who need to be taken from their workplaces urgently, as a matter of urgency, to protect them. As soon as we become aware of those kinds of situations, violence, cases of abuse, well, we're lucky in Quebec insofar as we have excellent grassroots community organisations, such as RATMAC, that are highly proactive, and we work closely with them to find solutions. Sometimes we have to remind the employer of their obligations. Sometimes we work with RATMAC to help employees get urgent emergency permits and to help them meet their financial needs at another farm in the region. Services Canada needs to investigate these cases of abuse and penalise those employers who are culprits.
8 seconds, Madam Kwan.
Well, I guess the one thing I want to point out is this. Sometimes when a worker comes forward to make a complaint and the fallout for them, even if they were able to get an open work permit under the Vulnerable Workers Open Work Permit program, they're blacklisted. And so therefore it's very difficult for them to actually manage through all of this. So I guess at the end of all of this, there's a system problem with Canada's immigration stream related to migrant workers, and that's something I think we need to turn our minds to.
Thank you, Madam Kwan. I would, on behalf of the committee members, as its chair, I would thank the witnesses for their time and contributions. And Madam Breckweld, Mr. Clerk will be in touch with you for you to appear at some point in time, either personally or whichever works. So, colleagues, one quick administrative matter before we finish. We have prepared a draft budget for this study in the amount of 500. Is there a motion to adopt this budget? Mr. Radikop, Madam Jahid, and all in favor? Carried. The committee will not be meeting next week, and when we come back on Tuesday, November the 21st, we will be continuing with the study of closed work permits and temporary foreign workers. Thank you very much again, and the meeting is adjourned. And I want to thank, the interpreters today. Excellent work, and thank you again.
Thank you, Chair, and everyone. You have a good weekend.